Hello, my name's David Runciman, and this is Past, Present, Future, the History of Ideas podcast. Today, it's the last episode in this first batch in our series Politics on Trial. There are going to be plenty more. Today, I'm talking about another trial that has many, many epic qualities. A very dramatic trial. The trial of Charles I at the end of the English Civil War that resulted in his execution. It's one of those trials, like a number of the ones I've talked about already, that feels like it was a foregone conclusion. Here was a king who'd lost a civil war. He was going to get his head chopped off. It wasn't a foregone conclusion. It was anything but. For this series about trials that took place a long time ago, the way I try and approach it is, first of all, to read the transcripts of the trials, which do exist with the exception of the trial of Socrates. They're not like contemporary court transcripts. These are various kinds of official records. It's not completely clear how much has been adjusted or altered or tampered with. But the odd thing about it, whether it's Joan of Arc or Thomas More, Galileo, is how alive they feel when you read them. They're like dialogues, a lot of them. This is one of the reasons why they end up producing these remarkable plays. And even if this isn't the authentic record, there's a feeling that you are listening to people arguing with each other. Even in the case of Socrates, where there's no transcript, that version of his speech by Plato, maybe I'm just using hindsight to make this interpretation, but when I read it, and I'm ashamed to say I'd never read Plato's Apology before recording the episode about the trial of Socrates, when I read it for the first time, it felt really alive. You believed that Plato had been there, and he had been there. So whether he was tailoring it, misremembering it, it had that alive quality that these trials all do, because even when they are very choreographed and regimented and the outcome is known in advance, everyone knows what's going to happen. Everyone knows in a way what's expected of them. When the defendant and his accusers, his or her accusers, in the case of Joan of Arc and Mary Queen of Scots, come face to face, there is something unpredictable about it. And even in the official transcripts, it comes through. But it's also the case that for some of these trials, there are really great modern books written about them. So for the trial of Socrates, I talked about the book by the American journalist I.F. Stone, a really interesting book about the trial, but also interesting because it was very much about Stone himself, too, a great crusading, campaigning journalist in mid-20th century America who had experienced McCarthyism. And so his book was partly about Socrates and partly about the thing that he was preoccupied with. What happens when a democracy, in his case, 20th century American democracy, turns on its own principles? And how can someone accused under those conditions defend themselves? For the trial I'm talking about today, there's another truly great book that I want to flag up at the beginning. It's by the lawyer Geoffrey Robertson, and it's called The Tyrannicide Brief. It's about the trial of Charles I. And like I.F. Stone's The Trial of Socrates, it's not just about the trial. It's also about Robertson's other life, because he is a lawyer, a very distinguished human rights lawyer. And he published his book in 2005. In 2005, Saddam Hussein was on the way to being tried. The trial was going to happen a year later. He'd been captured 2 years earlier. And various lawyers were preparing the brief, the tyrannicide brief, because Saddam Hussein was going to be convicted and executed just as Charles I was. It was also, I think, 2 or 3 years, 2005, into the trial of Slobodan Milosevic, another trial of a so-called tyrant. In that case, it ended in Milosevic's death a year later, not because he was executed, but because he died. He was found dead in his cell, and so the trial had to come to an end. But Geoffrey Robertson, in his book about Charles I, makes explicit reference to these two trials and other trials too, the Nuremberg trials that I'm going to talk about later in this series, the great 20th and 21st century trials of tyrants, of war criminals, of people accused of genocide. And Robertson makes the argument that the first version of this kind of trial, the people who it's going to sound like I'm trivializing it, but I'm not, invented the genre were the people who put Charles I on trial and who executed him, who condemned him to death for tyranny. And what's so fascinating for Robertson, and I think for anyone actually, about the trial of Charles I, one of the reasons that the conclusion was not a foregone conclusion, is that because these were the people who did it first, in a way that we moderns might recognize the continuity from that trial through to later trials, because they were the first, the originators, they were making it up as they went along. They didn't know what they were doing. They didn't know the grounds for the case they wanted to build. They didn't know what kind of court was appropriate for this kind of trial. They didn't know how to deal with a king. They didn't know what they should or shouldn't allow the defendant in court to say, what kind of defense was possible. The other thing that's fascinating about Robertson's book, The Tyrannicide Brief, is that it's actually the story of two trials. So the first, 1649, a king, Charles I. The second, in 1660, the trial of a commoner, a man called John Cook. Both were treason trials. In both cases, the defendant was accused of treason. Both resulted in the death of the defendant. In the case of Charles, by beheading. In the case of John Cook, he was hanged, drawn, and quartered, a fate that is almost indescribable. John Cook was the prosecutor of Charles I. So John Cook was the man who made the case in the court that was convened and held in Westminster Hall in January 1649, and that resulted in the execution of a king. And when Charles I's son came back and resumed the throne in 1660, he pursued with real vindictiveness the men who'd been responsible for the death of his father, prime among whom was the prosecutor. Geoffrey Robertson says that of these two trials, one was a show trial and one wasn't. But perhaps surprisingly, the show trial was the trial of John Cook, the 1660 trial of one of the regicides, as they were known, a man who was convicted of killing a king. Everything about that trial was a kind of performance. Everyone knew what would happen. There was no way he was going to get off. People knew their roles, including, it has to be said, the defendants. They knew what was coming. It was fixed. It was rigged. There was almost no due legal process. Geoffrey Robertson says that the trial of Charles I wasn't a show trial in that sense. In another sense, it was a show trial because it was understood that it had to happen in a way that displayed what was being attempted. There was a decision not to do this in secret, not to do it in private, in Westminster Hall, in front of an audience, members of the public, journalists. There was a press gallery. 6 journalists were allowed. There were many ersatz newspapers being published in London around this time at the end of the Civil War, and there were reports of what had happened in court. This had to be a trial in which the case was displayed. So that's a show trial of a sort, but in a way, every trial is a show trial in that sense, every trial that takes place in public. What it wasn't was a foregone conclusion, a fixed, a rigged affair, for a whole range of reasons. One of which was there was real disagreement among the people who put Charles I on trial, including Oliver Cromwell, who was one of the driving forces behind it, but not the only one. And he wasn't at this point the dominant figure that he was to become. He was on the way to becoming the dominant figure among the victors of the English Civil War. Cromwell wasn't sure, like all of his colleagues weren't sure, what to do with the captured king. And there were lots of options here. There were some people already who were determined that not only Charles should be put an end to, but kingship should be put an end to. There were already some people, but they were not the majority, who were determined that this civil war would lead to England becoming a republic. Many of them inspired by the Bible, by the Old Testament, and the arguments there against kingship, not just against this king or that king, but the idea of kingship. A godly people were going to rule themselves. But that was a minority view in 1648, late 1648, when it was decided something judicial was going to have to be done with the king. Another option at the other end of the scale was to try and find an accommodation with Charles so that he would continue to rule, but under very, very, very strict conditions, as a kind of puppet king, controlled by Parliament, controlled by the army, who were basically the people in charge by this point. And then between those two options, there was exile, There was the possibility of getting rid of Charles one way or another, maybe even including execution, but putting on the throne one of his children, not his eldest son, Charles. It was already clear by that point that he was a lost cause for the Republican or the victorious side in the Civil War. But one of his younger children, perhaps, or maybe the whole Stuart family were a write-off. Maybe another dynasty should be invited to take on the throne. None of this was settled when Charles was going to be put on trial. And it was sort of worked out as they went along. By the time it was clear they were going to have to kill the king, and it became clear in some ways during the trial did not begin with an absolute determination that it would result in execution. So in a way, it was only once Charles's fate had been decided through the process itself that a template of a sort was set for this kind of trial. Even then, during the proceedings, a lot depended on Charles, on the king. A lot of the uncertainty was uncertainty about what he would do. In a show trial, the kind of show trial where the outcome is determined in advance, it doesn't really matter too much what the defendants do. They will be encouraged to confess their guilt. But in this case, no one knew what Charles would do, and there were lots of different outcomes depending on his choices, as well as the choices of the people presiding over the court. And behind that, there was a deeper uncertainty. Before the decision to put Charles on trial had been taken, there were other options. There were other things that his captors, the people who had him in their power, they had physical control over him, could do, one of which was just to have him murdered. Some of these questions, some of these dilemmas directly echo the choices that Queen Elizabeth faced when she had in her possession Charles's grandmother. Mary, Queen of Scots, was the grandmother of Charles I. Wouldn't it be easier if someone just poisoned her, if she was disappeared in the middle of the night? And there were serious discussions in the Army Council in England in late 1648 about whether what was really needed here was to hire a poisoner. The trouble with that, even though there was a kind of history of getting rid of kings that way, he wouldn't have been the first king to have been bumped off in the middle of the night. It was a version of dynastic politics. The tradition was the tradition of dynastic rule and the fights between and within families over who gets the throne. It was Game of Thrones politics. And the new rulers of England didn't want to play Game of Thrones politics. They'd partly fought the Civil War in order to break the spell of that kind of politics. The other option would have been to put him on trial, but in a military tribunal. So there was a well-established set of rules about what could be done with captured generals, the military leaders of the other side, and Charles could have been presented as the military leader of the royalist cause. And some of his generals, Charles's generals, had been tried and shot following military tribunals. Two of his generals, the previous year to his trial in 1648, after the Battle of Colchester, were put in front of a court-martial and they were shot. And they could have done the same with Charles, and again, that was seriously considered. But the trouble with that is that it would have made England look like it was under military rule, that it was a military state, which was kind of true. It was, but that wasn't the look that they wanted. They wanted something with a more durable legitimacy than mere martial law. And the legitimacy that they were looking for, partly through this trial, was the legitimacy of a stable form of rule in accordance with the traditions or principles of English government. And so that's what this trial needed to do. It needed to find a way of establishing the legitimacy of the new order in the way it dealt with the king, the representative of the old order, in a way that people would recognize as consistent with principles of English government, but under conditions in which there was no precedent, there were no rules, and such rules as there were simply didn't make sense. So, for instance, how do you charge a king with treason when the established rules of English law is that treason is a crime against the king? Treason was basically either conspiring or imagining the death of the king. So if you're going to have proceedings that might result in the death of the king, how come you're not the ones committing treason? And of course, that was going to be the case 11 years later against John Cook. That was treason. This whole proceedings were treason. Somehow treason had to be adapted as a crime to encompass what Charles had done. It couldn't be a jury trial because juries were the peers of the defendant, and there were no peers, no equivalents of kings. This is the argument that was also had in the case of Charles's grandmother, Mary Queen of Scots. It was the case that she made to her accusers. You can't try me because a queen or a king can only be tried before a court of queens and kings. But this case was much harder than the case of Mary Queen of Scots, because at least in that case, there was another queen. There was another monarch, Elizabeth, and though Elizabeth was very reluctant to get involved and had to be dragged kicking and screaming to the end point, nonetheless, it was clear that there was a monarch behind those proceedings. Not in this case. There were no kings or queens to be seen anywhere in the trial of Charles I, except for the man who was on trial. So who could possibly preside over these proceedings? It had to be invented as they went along. And for that reason, it was a very precarious business. It was a very dangerous business. And everyone recognized at the time that there were lots of ways that this could go wrong. Not least because Charles was still a very dangerous man. The Civil War was ostensibly over, but not in the mind of King Charles, who was determined to carry on the fight. The Civil War, the thing we call the Civil War, is really two wars. One, the First Civil War, that ended in 1646, and then another one that resumed then and ran through to 1648. And Charles wanted a third. He was trying to rally his forces in Scotland, in Ireland, trying to see on the continent of Europe who would come to his defence, trying to galvanise the pockets of royalist resistance that still existed in England. He wasn't done by any means. There were royalists in London where this was taking place. So to put the king on trial and to be responsible for the proceedings was to put yourself in personal danger. The men who did this, one of the decisions that they took once it was clear they were going to have a public trial of the king, was literally to line their hats with lead, because it was more than likely that someone would take a pot shot at them. And it was dangerous for the other reason, which is if the trial went through to a conclusion which resulted in the end of Charles. Charles did have supporters and allies, and he had children. There was still a dynasty out there. And the Civil War had been a very precarious business in itself. The establishment of a new regime in England was going to be a seriously difficult piece of work. Who knew what might follow? Who knew how stable it would be? Who knew what being responsible for the death of the king might look like if the regime that followed was itself more precarious than its supporters hoped? For all these reasons, there are a lot of brave men. This had been a civil war. Courage had been tested in different ways, who weren't brave enough for this. Lawyers were needed in London at the end of 1648 to put the king on trial. Someone was going to have to make the case. The case was going to have to be drafted. The proceedings were going to have to be established and justified. There's going to have to be a reason why this court is convened in this way. And it proved quite difficult to find people who wanted to take this on. So in the chambers that still exist today in places that still have the same names, the Inner Temple, the Middle Temple, the places where lawyers worked and gathered in London in 1648, they were suddenly a lot emptier than they had been a week or two before, when it was clear that Cromwell and his allies were looking for lawyers to do this work. A lot of the lawyers they were looking for disappeared to the country, many of them encouraged by their families, by their wives. There's a series of records of the wives of lawyers and parliamentarians at this period saying this might be a good time to get out of London, because if it went wrong, it wouldn't just be the men who went down. Families go down with the men who get on the wrong side of the law or the regime. But one of the people who didn't flee, who was willing to take it on, was John Cook, who became the lead prosecutor in this case. And Geoffrey Robertson in his book writes about the reasons why Cook might have taken this case on, and it was probably a mixed range of motives, all recognizable human motives, partly a sense of duty, maybe some, not ambition, but recognition that this was an opportunity. Cook wasn't a particularly senior lawyer, and this was a damn big case. It's quite hard, if you have the taste for it, to turn down an opportunity like this if you also feel that it's your duty. And then on top of that, there was a higher sense of duty, not just to the politicians and to some of his colleagues, but to God. He was a God-fearing Puritan, and he believed that the side he'd been on in the Civil War, the parliamentarian side, had been doing God's work, and this would be the creation of a godly kingdom after a form of rule, Charles I's rule, which made it very hard for men like him to lead the godly lives they wanted to lead. That whole combination of factors persuaded John Cook to take on the case. He didn't do it alone, but he was one of the leading lights in these proceedings. And he had to, with the help of others, come up with an answer to a series of very difficult questions, which you can kind of divide into two parts, I think. So there were the questions about the court itself, its legitimacy, its authority to try the king. What kind of court could do that? On what justification? How was the answer going to be given to the question that everybody knew that the king would ask when brought up, placed in this court in front of his accusers before a public audience? Everyone knew the king would say, "By what right do you do this? I am your king. I am your God-given king. You do not put me on trial." They had to have an answer to that question, and then they also had to have a case. So two really very separate questions in a way. What justified the proceedings at all? And then, if the proceedings could be justified, what was the case that this man, this king, had to answer? So to take the first question first, how did they justify the court? It was a mixture of things. So the formal authority for the tribunal that was going to try King Charles came from an act of Parliament. And it was understood that Parliament had the right, through an act, through legislation, to convene judicial hearings for such purposes. If Parliament decided, even if there was no precedent for such a court, that such a court should be created, it was created by law, by a lawful act, an act of Parliament. And that's what happened in late 1648. Parliament enacted this court. But then the question is, because there's always a question behind the question, by what right does Parliament do that? How does Parliament have the right to decide in what place and in what way a king should be put on trial? And that couldn't be explained by another act of Parliament. It wouldn't make sense. Then you're just going round in circles. Then the justification moves from legislation to common law or principle or tradition, the understanding, including in Magna Carta, but also in English history, that Parliament was a representative body of the people, and acting in that capacity, it did have the authority or the jurisdiction to make sense of complicated questions of rule and right. And various precedents were cited for the ability of Parliament to essentially decide on questions of who and how the realm gets ruled, including a very recent one. Charles's father, the son of Mary Queen of Scots, the father of Charles I, James VI of Scotland and first of England, had become King of England partly with the blessing of Parliament. It wasn't an election. It wasn't as if, when Elizabeth died, Parliament picked from a range of candidates and said, "We have chosen you to be king." But everyone understood that James could not have become king if Parliament hadn't allowed it and indeed encouraged it. Parliament, it was understood, did have a kind of authority over kings. And that was held up as part of the justification in this case. But there was a real problem for the parliamentarians, which was, if Parliament in principle has this kind of authority to make these kinds of decisions, this Parliament does not look like it meets the minimum criteria for being a legitimate Parliament. Because the trouble was, in 1648, the Parliament in question, the Parliament that passed that act, the Parliament that was going to try the king because it was part of parliamentary proceedings, was what is now known as, and was known then as, the Rump Parliament, a Parliament that had been shrunken right down to a core, the core being essentially the ones who were approved by the army, by Cromwell, by the regime that found itself in power. It had excluded the House of Lords. So this was a parliament without lords. It was just commons. And in that long tradition going back to Magna Carta, nowhere in it does it say you can have a parliament which is just commons. It has to be lords and commons. Charles knew this. His accusers knew this. At one point during the trial, Charles simply turned round and said, "I see no lords here. This isn't a parliament. This is a mockery of a parliament." And it was worse than that, because the rump wasn't just the Lords had been excluded, many MPs had been excluded. It had been shrunk to less than half of its traditional size. Fewer than 200 MPs were left, because all of the ones who were accused of, suspected of having mixed loyalties, and some of them of simply being on Charles's side, were out, including all the Presbyterians. Charles had been negotiating with Presbyterians in the hope that he could find some kind of arrangement in which they would support him in return for him allowing for a Presbyterian settlement in England. All of those MPs were out. All of the ones who were suspected of not being loyal to the new Army Council regime were out. It was a parliament of stooges. So it might not have been a show trial, but it looked to a lot of people like a show parliament, not a real parliament. So the justification, in principle, just about defensible, but in practice, de facto, it looked really thin and really weak. And they were very aware that Charles might try to exploit this. But there was another line of defense, which was simply the de facto defense. We can do this because we are the ones in power. Someone has to be in charge. We've just been through a civil war. It was chaos. There was no rule. At the end of the war, the people who are establishing order, maintaining order, the accusers of Charles could say, are us. It's the army. It is Cromwell and Cromwell's supporters, including his supporters in Parliament. We are the ones in charge. And that gives us the right to do this. Now, that might sound like a very weak line of argument. We're here because we're here. We can do this because we can do this. That's what it sounds like it's saying. The most circular argument of all. Why are you allowed to try a king? Because look, here we are trying a king. It was actually a very powerful argument. It was made in the court by the presiding officer of the court. It was made by John Cook. When Charles questioned the authority of the court said, "Look, this is a court. We are here. You are on trial. This is the answer to your question." Part of the reason it was so powerful is that the counter-argument was very weak. They were doing it. No one was stopping them. No one was trying to stop them. If this really was some kind of usurpation of authority, if this was a group of people who were faking it, where was the force on the other side? Yes, there were soldiers in the courtroom. Yes, the population of London was aware that it wouldn't be a good idea to riot at this point. But actually, the population was pretty cowed anyway. There was very little resistance to these proceedings. Almost all the resistance came from Charles himself. The people presiding over the court were able to say, this looks like a court, it feels like a court, it smells like a court, QED, it is a court. They were also able to say, this is itself an established precedent of English legal and political tradition, because it is often the case that we have been through regime change, when a dynasty is replaced by another dynasty, when a king takes over, but there's no time to crown him yet, not to go through the official ceremonies. There are lots, and have been lots in English history, of interim regimes that are establishing themselves, trying to reassert authority to save the nation from more bloodshed, from more violence, from civil war. And it's recognized that under those conditions, the people who find themselves in power have to be allowed to exercise sufficient power to maintain order. De facto is de jure in those conditions. And just as a side note, it's also worth saying that that argument was accepted by, I think I would say now, the single most famous, celebrated defender of the royalist regime in print, the greatest of all English philosophers, Thomas Hobbes. Thomas Hobbes was a royalist. He was on the side of the king. In 1642, at the start of the Civil War, he published works that were in defense of the regime and said that the people who were taking arms against the regime had no right to do that, even to contemplate it. You have to obey the regime that you've got. But because that was Hobbes's argument, when he came to publish his most famous book, Leviathan, in 1651, after the execution of the king, but written during the period leading up to and after the end of the Civil War. He bit the bullet and accepted that if the argument for not taking arms against the king was that you can't do that against the established power, by that point, the established power lay in the hands of the king's enemies, and therefore there was an obligation to obey them. De facto becomes de jure for Hobbes. Now, if that argument was sufficient for Hobbes, it was probably a pretty strong argument. Then there was the other question. What was the case that was going to be made against Charles? This was really John Cook's business. He was going to have to prosecute. So unsurprisingly, they threw the book at him. They, to start with, just said this man is a monster, a tyrant, a murderer. The official case was treason, tyranny, and murder. But then the longer version of it included rape and pillage and destruction and cruelty, everything they could think of. Geoffrey Robertson in his book has a great line where he says, because time was really tight, and it was really tight, John Cook only had a couple of weeks to come up with this case. It was only really decided the trial would go ahead at the beginning of January 1649, and it started on the 20th of January. And Geoffrey Robertson says in the Tyrannicide brief, under pressure of time, it's very hard not to be prolix. That is, the less time you have, the more stuff you throw into your case, into your brief. It's like the famous line that, I'm not sure who wrote it, but in a letter where the letter begins, I'm sorry, I didn't have the time to write you a shorter letter. Under pressure of time, you throw the book at the person. This was true in the case of Joan of Arc. To start with, when they first came up with the case against Joan of Arc, it had 70 charges against her. It was only when they took their time that they got it down to 12. In those 2 weeks, they did shrink the case against Charles, but not by much. It still was treason and tyranny and murder. And part of the problem there is that there had just been a civil war, and the things that were being listed against Charles were things that I think everyone was aware. Some of the rape, pillage, murder had happened on both sides. This was a civil war. Civil wars are unbelievably brutal. For many people, the worst kinds of wars are civil wars, partly because there aren't really any rules, and so it's very difficult to know exactly what is and isn't permitted. It wouldn't be hard for the defenders of Charles, and maybe for Charles himself, to say, well, you did all this too. Leaving aside tyranny, but treason, he would certainly say, who were the treasonous ones here? I was king, and now you're about to put me to death. But also, more straightforwardly, this was a civil war. This happened on every side. And given the case was the people, through their parliament and parliament's appointed representatives, against Charles, the other obvious weakness is every time the phrase the people was invoked in these proceedings, people in the courtroom and outside might be thinking, well, weren't at least half the people on the other side? What is this people? You're talking about the people as a unified entity when we've just been through 6.5 years in which half the people were trying to kill the other half. And at one point during the trial, a female voice was heard from the public gallery. No one ever knew who said it because by the time they tried to drag her out, she had gone. But when John Cook invoked the people in the case against Charles, a voice could be heard from the public gallery saying, not even half the people. Then the sergeant-at-arms said, if anyone else breathes a word, you will be shot. And it was quieter after that. But it was a point that everyone knew could be made. And so it was clear that this had to be a case that could be pinned personally on Charles. If this was a broader case about the stuff that had gone on, it becomes weaker. The stronger case is that even in the context of what had just happened over the previous 6 years, this man before us in this court is personally responsible for it. Not the half of the people that fought on his side. They're not personally responsible any more than the half who fought on our side are personally responsible for what happened. There is only one person in this kingdom who is personally responsible for all of the horror, and it's the king. And it was a case that could be made for two reasons. One, and this was a fixation of the proceedings against Charles, the argument could be made that Charles had started the war. And the argument was made. A lot of discussion was about who took up arms first, and the prosecutors of Charles said that he did first in 1642. That was arguable, and he could have said he only did it in self-defense because it was clear that the other side were coming for him by that point. I'll come on to the self-defense in a moment. But what made it a stronger case was the fact that when the First Civil War came to an end, Charles tried to start a second, and no one was in any doubt at that point who wanted the war to continue. It was Charles. And now here he was in 1648, early 1649, trying to start a third. So even if it was arguable who had started the first, no one was in any doubt about who was behind the second and trying to start a third. Because he was trying to start a third was one of the reasons they decided they had to do something about this man. That was one of the pragmatic de facto reasons he was on trial. But on principle grounds, he was responsible because he bore the responsibility of the man who kept the fighting going. And secondly, the other reason that the case could be made personally against him was because he was a king. Not only was he a king, he believed he was a king, he believed he was an absolute monarch, he behaved like a king. And he behaved like a king during the war, which meant he liked to take personal authority and he liked to take personal charge of proceedings when he was present. So in a war, the question of who is personally responsible for war crimes can be difficult to establish, especially if people are able to say they were just performing their roles within a wider organization, say within the New Model Army. Maybe even the people who ran the New Model Army might be able to say, I wasn't doing this as some kind of personal authority within the army. The army is what has the authority, and we are all playing roles. But Charles could never say that because he never believed it. He didn't believe he was king playing a role which was defined and limited. He believed he was an absolute monarch. And so they were able to provide evidence from eyewitnesses who were there, who said when Charles was on site, on the ground at this battle or that siege, and a question arose, do we torch this town? Do we kill these people rather than give them quarter? Charles was very happy to be the person whose authority was referred to. He was personally asked, do you approve this? And he said yes. And he said yes as someone whose authority could not be questioned. And for that reason, he was liable. That was the case against Charles. So what was his defense? What defense could he make against this? He had three options, essentially. Once it was clear it was going to be a real trial in a real court in front of a public as well as a political audience, there were three things he could do. He could refuse to recognize the authority of any court to try him under any circumstances. He could invoke the rights of divinely authorized kingship. He was above any legal proceedings of any kind. That was one option. The second option would be to say, I do not recognize this court authorized by this parliament, because this is no parliament. This is a shadow, not just a rump, but a shell of a parliament. This is a body of men who have just come together for a particular political purpose, which is to do away with me. And they have no right to claim the authority of the traditional Parliament of England. Or he could have taken a plea, not guilty. He could have said, which would be implicitly recognizing the authority of the court, I didn't do it. And probably under those circumstances, the best case would have been self-defense. In the same way that his grandmother, Mary Queen of Scots, and this was recognized by Elizabeth, was able to say repeatedly, when a king or queen, a monarch, is captured, is under lock and key, everyone recognizes that that person, that royal person, has the right to do whatever they can to escape, to re-establish their freedom. Kings have to be at liberty to seek their own liberty. And so once he was captured, yes, he might be guilty of trying to rally his supporters and find people who would free him, just in the same way that Mary Queen of Scots was known to have done that. And in the time of Elizabeth, it was recognised that wouldn't have been enough to convict her. The only way they were going to convict her was to find her guilty of plotting to kill Elizabeth. Well, that was not going to be possible in the case of Charles I. No one was going to find him guilty of plotting to kill the king because he was the king. This is the difference between his trial and his grandmother's trial. So he could have made that defense. He could have probably got some pretty smart lawyers to make it for him, and it would have been awkward for the other side. They would have had to really go into detail on this question of who started it, when, and also gone really heavy on his personal liability for war crimes. It would have become not so much a treason trial or even a tyranny trial, but a murder trial, a war crimes trial. Charles chose the first option. He refused to recognise the authority of the court at all. In terms of achieving an outcome other than the outcome in which the trial resulted, the death of the king, that was probably the worst option. And not only was it the worst option, he did it badly. So to read the transcript of the trial is to see that there were moments, including right at the start of the trial, where he said, bluntly, to the court, "By what authority have you brought me here?" Pause. If he had carried on with the pause, thrown it right back at them, it might have been awkward. I don't think the result would have been any different, but he might have put them on the spot. However, he carried on and he started whining and he started elaborating his own case, which was that he was a king. Kings shouldn't have to suffer in this way. He had always looked after the interests of his people. He was doing whatever he did because he was authorized by God to look out for the liberties of his subjects. And on and on. The issues over which the war had been fought, the issues that in a way had been decided by the outcome of the war. And he sounded whiny, unrepentant. His lack of repentance was fatal for him. He was overheard being taken down from the courtroom, muttering about the fact he regretted none of it. The only thing he regretted was the execution of his ally, the Earl of Strafford, before the Civil War had even started, that he allowed that to happen. Only one death was on his conscience. That was the death of one of his people. All the others who died didn't care, and willing to have more die to re-establish himself as king. So he chose the worst option and he made the case badly. He flirted with the second option. So, for instance, when he said, "I see no lords here," he knew that this parliament was a weak instantiation of the real thing. But he also knew if he was going to take the first option, he couldn't take the second. They were mutually exclusive. Once he said, this isn't a real parliament, he would be implicitly accepting that were it a real parliament, it might have the right to try him, and he couldn't bring himself to do that. He was caught in some ways by those two choices. The second one, I think, would have been harder for his accusers to answer. They were aware it was a real weak spot. And he was never going to do the third, because the third, self-defense, would have recognized the authority of that court. He didn't want lawyers. He defended himself. He didn't want to give anything away that might suggest, hint, that he accepted the authority of these proceedings. Would a self-defense case have worked? Probably not. But what it would have been is the thing that many people suspected, some hoped, more feared might be the result of the trial, which would be negotiation, that actually the king would turn it into another negotiation about the conditions of his captivity. So if he'd gone down the not guilty self-defense route, it might have been the case that he could have opened up divisions within the people who are now running the country, some of whom might have wanted to say, okay, he hasn't really got a case, but he's talking to us now. He's recognized our authority. Can we find a way to work with this man? But none of that was possible. There was no negotiation possible of any kind with a defendant who refused under any conditions to recognize the authority of the court. And the way he signaled his refusal was to refuse to plea. So he was repeatedly asked, in fact, more or less the sum of the trial of the proceedings are the attempts by the court, constantly being goaded by Charles to justify their authority, the attempts by the representatives of the court to get Charles to make a plea, guilty or not guilty, and he repeatedly refused. And so they warned him that under the traditions of English law, English common law, refusal to make a plea is considered to be the equivalent of pleading guilty. so that if he wouldn't plead, he would be found guilty. He would have been found guilty out of his own mouth by his silence. He was told that. He refused to recognize the authority of the court, which was taken to be a refusal to plead. And so there was no trial of Charles I because it never got going. The case that had been prepared against him, including the witnesses who would be brought to testify for the things that he'd done on the field of battle, and the evidence that would have been produced from 1642, 1645, 1646, 1647 about his responsibility for the war, for it starting, for it continuing, for all of that bloodshed. None of that was presented in court. It was eventually presented after the decision had been made that he was guilty, but before sentencing, in a private sentencing hearing, which was held outside of Westminster Hall, in a separate gallery. And also this proceeding was made up as they went along. There was no precedent for this, but they were determined that the case would be heard. It would at least be presented so that it could be published. And after Charles's death, John Cook's case, a book called King Charles the Case, was published with all of that evidence of his war crimes. He wasn't going to get away with not having that heard, but it wasn't heard in the trial itself. The trial ended before it started because Charles was guilty, and because he was guilty, he was sentenced to death because the thing that he was guilty of was treason. Because he was very high-born, he was spared being hanged, drawn and quartered, and he was given what was thought to be the dignified, aristocratic, merciful release of beheading. So that's what happened in this trial. As a calculation about his best tactic during the trial, the choice Charles made was disastrous if what he wanted was some outcome other than the one that ensued. But as a decision about what would happen after the trial, it was the right one, because it allowed Charles to be portrayed as a martyr. On the day that the case against Charles was published, another book was published called Icon Basilicae, which was a fake autobiography of the king, in which he was portrayed more or less as Christ, as a Christ-like martyr, a man who gave his blood for his people, a man of astonishing dignity, quasi-divinity, breathtaking humility. When the two books were published in early February 1649, the pro-Charles book vastly outsold the case against the king. And that was just an early hint that Charles's decision not to recognize the authority of the court would pay dividends not for him personally, but for his family, because his family would be able to use that if and when they were able to return in order to make the case that the regime that had existed between Charles's death and the restoration of the monarchy was illegitimate. In 1660, the Stuarts did return, and they did make that case that the regime that had been instituted in 1649 had become a republic, had not had a king, but had had a pseudo-king eventually in the form of Oliver Cromwell. And when Cromwell died, the republic's weakness was exposed, the weakness that in some ways also lay behind the agonized contortions in the trial of Charles, which is how do we legitimate ourselves? That question, are we legitimated by military force? Are we legitimated because actually what we are going to do is institute our own version of monarchy? Or are we legitimated because we are the true parliamentary representatives of the people? Without Cromwell, who was a kind of monarch, there was no satisfactory answer to that question. They couldn't find another pseudo-monarch. Cromwell's son was no good. Parliament was too divided, and in 1660 there was an election to Parliament which returned a majority of royalist MPs, so Parliament wasn't going to work. The army was divided, but also the army knew that it couldn't sustain in the long run rule simply by martial law, by military force, and the regime fell apart. It fell apart because in the end it couldn't answer the question, which lay behind the uncertainty of the trial of Charles I, but actually I would say was quite effectively answered in the trial of Charles I, but only because it was a powerful de facto case. Look, we are now in charge. In 1660, they weren't in charge. They were increasingly not in charge. The de facto case fell apart, and Parliament enabled the return of the king. When Charles II was restored to the throne, he knew that he had to be very careful about who he punished for what had happened before. For that reason, that if half the country had been on the king's side, and that voice called out in the trial only half the people at best, the same could be said the other way. To punish people for the war itself suggested at least the possibility that half of the country was going to find itself under attack, under threat, and that was no basis to restore stability. So a very conscious decision was taken to offer clemency, forgiveness, oblivion, as it was called, to anyone involved in the war, involved in the regime that existed between the execution of the king and the restoration of his son. There was a blanket amnesty for almost every kind of implication in all of the forms of English politics from 1642 to 1660, with one exception. A very clear decision was taken that the only thing that could not be accepted, forgiven, wiped clean, was the trial. The men who would be hunted down, and they were hunted down, some of them in the United States of America, were the men who were the regicides, the people responsible for the death of the king. That was the unforgivable act, and by ring-fencing it, it allowed everyone else off the hook, but it also allowed a focus for the righteous anger of the royalists, who wanted to say the one thing that can never be forgiven is calling a king treasonous, because treason has to be a crime against the king. There was no authority for those proceedings because they were a contradiction in terms. And now that monarchy has been restored, we can see that. And the traditional laws and rules of treason were re-established. If you do this stuff, if you even imagine the death of the king, we will come for you and we will cut you into 4 pieces, but we will torture you first. And that's what they did to the men who had presided over the trial, including John Cook. In the tyrannicide brief, Geoffrey Robertson describes the trial of John Cook. And it was a show trial, as I said at the beginning. It was a jury trial, but the jury was picked, it was fixed. The jury in the trial of all of the regicides was encouraged not to retire, as was traditional, to go and discuss their verdict, because the verdict was obvious. They were told, you don't need to retire, you don't need to discuss this, just convict. We've all heard the evidence. There is no possible defense for these men. The defense would be making a mockery of you and your intelligence, that you can commit treason by being a king, that to kill a king, which is what these men did, is not treason. Guilty, guilty, guilty. Hanged, drawn, and quartered. The lot of them. John Cook tried to offer a defense, a version of the kind of defense that might have been offered had the other side won, had the royalists won, by some of those who fought for the new model army. A familiar line of defense, which was, he wasn't personally responsible. John Cook was not a man of authority. He wasn't a king. He wasn't a nobleman. He was just a humble lawyer. And he was given a brief, just as a soldier might be given a task in war which requires him to do something that he wouldn't do in his own person, as they would say back then. So would a lawyer. Lawyers take the jobs they're offered. He didn't run away. He took this job. But it wasn't because he personally was bent on the death of the king. He was simply making the case. It was for the court to decide. The court did decide. The defense didn't work. No defense was going to work. But as Geoffrey Robertson says in the tyrannicide brief, we now recognize the absolute essential nature of that defense for all sorts of legal proceedings. Lawyers have to be able to say, in defending this monster, in pursuing this line of argument, I am not doing something with my personal blessing. I'm doing my job. And I took the case that came to me, as they say now, off the taxi rank. Not quite true in the case of John Cook, because there wasn't really another case like this heading anyone's way. But unlike all the other taxis that drove out of London as fast as they could with their wives in the back, he stuck around, so when the case arrived, he was the one who was there to pick it up. He picked it up, he prosecuted it. It wasn't even as if he succeeded, because there was no trial, because the defendant wouldn't plead. But he nonetheless made the case. He did put his name to the case, and the book that was published after the death of Charles also had his name in it and on it. So it was John Cook. He wasn't denying that John Cook did this, but John Cook did this as a lawyer. And though that court had no interest in that line of defence, I think it's fair to say that subsequent courts would have had an interest in that line of defence. John Cook was condemned and he was hanged, drawn and quartered, a truly terrible death, along with many of the other men who were involved in the trial, many of the men who had signed the king's death warrant. There were stories, some apocryphal, some not, about how reluctant many members of Parliament had been to sign the king's death warrant in 1649, presumably because some of them had a premonition of precisely this eventuality, that within their own lifetimes they might find themselves on the other side of the argument. The men who condemned and burned Joan of Arc at the stake were at least lucky enough to be dead when her second trial took place and she was rehabilitated and they were condemned, because if they'd been alive, they would have been burned at the stake. In this case, it was only 11 years, so not all, but almost all, of the regicides were alive. Cromwell was not alive, but they dug him up anyway, and they chopped him up anyway. But many of these men were alive, and they suffered a far worse death than the man that they had condemned in 1649. John Cook was, by all accounts, very brave. Some were braver than others under these conditions. The executions themselves are recorded in the diary of Samuel Pepys. There's one line that he says about one of those just before he was hanged, drawn and quartered, where Pepys said he looked as cheerful as any man could do under those conditions. John Cook was, in his way, one of the cheerful ones. He also believed that he was going to his glory. He had done nothing wrong. He had his faith to sustain him. He also said one or two remarkable things to keep the spirits up of his fellow condemned and also of his family, because it's agony for the families too. Not only knowing what's going to happen to the person being executed, but what's going to happen to them. They're going to lose their property, their security. It's a casting out into the wilderness to be the wife, the child of a convicted traitor. But John Cook tried to reassure them as best he could, including about the terrible suffering that he would endure. And he wrote one line in one of his letters that is remarkable to have been written in 1649, which is, "Yes, what is going to happen to me is terrible. The pain will be terrible. It will only be 15 minutes, he says. Actually, they drew it out. They made a particular example of John Cook, and they extended his suffering during the drawing part of the hanging, drawing and quartering. But he wrote, "It's not as bad as childbirth," which is an amazing thing for a man to write in 1649, though also true. Weirdly, George Bernard Shaw, in his preface to St. Joan, at one point says of her terrible fate, being burned at the stake, he said, "We have to remember that nature has equivalent tortures in store, including by implication for women. Childbirth without pain relief of any kind." And John Cook said, "I will suffer, but I will not suffer as much as women suffer under God's natural order of things. We all have to suffer in this world so that in the end we don't suffer in the next." It was a remarkable thing to say, but it's also hard not to think of the wives, the women in 1649 who said to their husbands, "Please don't do it. Be ill, be absent." I've talked a little bit in the earlier episodes about the 7 or 8 men who found a reason not to be at the trial of Mary Queen of Scots because it was precarious. The one brave man who went against what everyone else did, Lord Zouche, but the others, nameless, I don't know who they are, who were conveniently sick. The 3 men who chose not to sign the final verdict against Galileo. There are always people, always in these kinds of trials, who will look for a way out, always. But the wives who said to the husbands in 1649, "It's not worth it," they were right for themselves and for their husbands. John Cook did a heroic thing, but it is the wives who suffer. There are going to be many more political trials to come. We've only reached 1649, but so that we don't all get a bit trialed out, we're going to break this series up with other things. And that means we're going to be starting a new series next time of an old favourite, the history of bad ideas. I'm going to be talking to Mark Blyth, the economist, about what's wrong with austerity, to Helen Lewis about why genius is a bad idea. We're going to be talking to Dan Snow, the military historian, about the myth of the decisive battle. Shannon Valor is going to explain what's wrong with the idea of value-free technology. And we've got more as well. Meritocracy as a bad idea, charisma as a bad idea, monopoly as a bad idea. History of Bad Ideas starting next time with Mark Blyth on austerity, and then we'll be returning to politics on trial, taking the story much closer to the present. Do join us for all of that. This has been Past, Present, Future.